I'm Richard Burnham, aka The Indie Lawyer. Welcome back to my series Lawvel 101, where today we're asking, what can I do if someone infringes my copyright? In our last video, we looked at what parts of video games are protected by copyright. And in this video, we're looking at what you can do when someone rips off your copyright-protected assets. Now, if someone copies work from your studio, then copyright law gives you several options to stop them from continuing to do this. Of course, the flip side is also true. If you're using someone else's copyright-protected assets, then they can take steps to stop you from using them in your game. Now, there are various ways in which someone can infringe your copyright, and these include things like copying the content in any form, including in digital form, issuing or showing the work to the public, renting or lending the work, or adapting the work in some way. These are all known as acts of primary infringement. If someone does one of these with your work, then they're committing copyright infringement whether they mean to or not, and you can take action. They also can't do things like selling any of your work that are subject to copyright protection without a license, and this is known as secondary infringement. The difference between primary and secondary infringement is that for secondary infringement, you generally have to know or have a reason to believe that you're committing copyright infringement. Simply suspecting isn't enough for this. How do you know when someone's actually copied your copyrighted work? Well, with LDMA copyright, there needs to be a link between your work and the work that's copying yours. Like I said before, if you and I created something identical at a game jam, but without copying one another, then that wouldn't actually be copyright infringement. And when we look at whether copyright has been infringed, we look at whether a substantial part of the original work has been used to create a new work, and this typically involves taking the original author's skill and labour and putting it into the new work. The more abstract the part that you take from a piece of work, the less likely that there will be copyright infringement. This isn't always easy to prove. After all, where does inspiration stop and ripping off begin? There's currently a very interesting case going on between the creators of Star Trek Discovery and a game developer regarding this point that I have a video planned for. I really need to stop saying that. Now, just because you've used someone's copyrighted work or they've used yours doesn't mean you'll necessarily find yourself in hot water. When it comes to the law, there are usually defences. You've probably noticed I used a number of copyright protected videos and pictures in my videos, and the reason I can do this is because I'm able to rely on a defence when I do so. The main defence is usually related around a concept known as fair dealing, which you've probably heard a bit about. In England and Wales, fair dealing includes things like using copyrighted material for studying or non-commercial research, reporting things like current events, or publishing something that's in the public interest. Another major one is criticising or reviewing someone's work, which is another form of fair dealing. Where you're reviewing or criticising a piece of copyrighted work, then you're able to use that work to do so, provided you sufficiently acknowledge the actual author and the work hasn't actually been available to the public. If I was to hack into your GitHub and steal a copy of your game and did a video critiquing it, well, I wouldn't be protected from you suing me because you wouldn't have made it public. Another big example of fair dealing is parody, pastiche and caricature, which I rely on a lot. This is an exception that allows you to use copyrighted material to create a parody-like content without obtaining permission from the rights holders. However, most jurisdictions have a concept known as moral rights, which includes the right not to have your work subjected to derogatory treatment, so you can't just do whatever you want under this. Now, fair dealing really isn't the catch-all defence that the internet suggests it is. In England and Wales, dealing just means doing something that would be copyright infringement, and fairness refers to how much of the original content you use. If you use more than is required to achieve your goals, or don't draw enough attention to the original author, then you're unlikely to be protected by fair dealing. Again, going back to my example of stealing your game, assuming you've now published it, if I just played the entire game on my channel and every 10 minutes said things like, well, that looks cool, I probably wouldn't be able to rely on review and criticism. My fan game Takedown series is a good example of fair dealing done right, I hope anyway, because the content is being used for the purpose of reviewing the content, reporting the legal position, and I acknowledge the actual right holders in a very clear way. Now, a good rule of thumb with fair dealing, and I stress this isn't legal advice, is to not take the mick with what you use. This is particularly relevant in the US, where fair dealing is more of a general defence that isn't limited to specific situations. Don't use more than you need to, and make sure you acknowledge the actual authors. And no, you can't use fair dealing to make a fan game. You just can't. So what are your options if someone's copied your work and you want to stop them from continuing to do so? Well, you've got a number of options. Copyright protection and most other intellectual property rights usually give you the right to claim back any money you've lost as a result of that infringement, which is known as seeking damages. You can also force the person infringing your copyright to pay you any profit that they've made from infringing your product and pay it to you. You can also ask a court to give you what's called an injunction, which is a court order that stops someone from doing something or compels them to do something in particular. However, an injunction is not an easy thing to get, and in the UK, if you're going up against an innocent infringer, meaning they didn't know that copyright existed in your work, you can take out an injunction against them, but you can't seek damages. Now, copyright also gives you the specific right to be compensated when there's been any serious breach of your work, and this includes things like uploading your game to a torrent site or giving it very derogatory treatment. You can also ask the court to make an order that any material that's in public or in shops be seized into your control to prevent it from continuing to appear in public. Of course, your right to bring action is subject to a few points. First, if the infringement happens outside of the country you're in, then you might need to rely on that country's local laws to take action instead of your own. Some countries have much looser approaches to copyright infringement, and they may not be as strict or really care that much about your rights. You also need the resources to actually do something about the infringement. You can send a scary letter to someone that infringes your copyright. They may care to take it down, but they may ignore it. You can send takedown notices to a website hosting your copyright infringed content, but they might also ignore it. And if both of them ignore it, and most often or not, you'll need to go to court to get an order to stop them from infringing your copyright. And whilst this is something you can do yourself, it's not for the faint-hearted. If you want to enforce your rights, usually you'll need some significant finance to do so, and in most cases, if you lose your case, you can be expected to be on the hook for your opponent's legal fees. This is typically where insurance comes in handy. And that, in a very brief nutshell, is copyright. The most confusing thing to get a head around is the category business. And hopefully this beautiful diagram that I've made helps make it a little bit clearer. It shows what assets are usually protected by copyright and what categories they usually fall into. As I said before, video games are generally quite annoying because different assets fall into more than one category, but you just need to remember that artwork is covered by artistic copyright, your story and code by literature copyright, and your music by musical copyright and sound recording copyright. Other key points to remember are that your ideas usually need to come out of your head, your work needs to be original, fair use doesn't mean you can do what you want with anything, and enforcing your rights isn't always easy or cheap. Now, if you've got any copyright questions, let me know below, and tune in next time when we'll be discussing trademarks. After that video, I'm going to tackle one of the most common questions I see developers ask: do I need a company to make games? Spoiler, the answer is no, but also maybe. Also, again, I'm in Cardiff on the 19th at the UK Hub Crawl. If anyone has anything they want to discuss in person, links in the description below. I'm also at GDC in March and keen to speak to any indie devs about any legal questions they have for an AMA video I've got planned. Until then, I'm the Indie Lawyer. Catch you later.